What fiduciary duty means is someone is literally standing in the client's shoes and making decisions for that client's best interest as if they are the client. And that is a duty that lawyers often have in set circumstances of the representation of a client. And when they're in that role, they then have to do what is best for the client despite themselves. But under Rule 4-113, an organizational client has an added component to it in that that lawyer, if he sees a shareholder, an officer, a director, or an employee of that corporation acting in a way that is illegal, that will harm the corporation, or is committing acts that are adverse to the corporation, that lawyer's obligation, his fiduciary duty, is to the corporation. So one other aspect of fiduciary duty is also illustrated in Rule 4-1.13. And that deals again with this organizational structure. And this is when the lawyer or law firm chooses to not only represent the corporation, but also represent one of the employees, officers, or directors of that corporation. If they're going to do that, they still have to comply with 4-1.7 and get an informed consent waiver of that conflict, of that dual representation. And the key thing is the individual in that corporate structure who has to sign off on that consent has to be someone who's appropriate and removed from that dual representation. It can't be the same officer that you're representing. It has to be someone other than that who's going to consent and have an informed consent to that representation, dual representation going forward. Unfortunately, there are times when lawyers breach their fiduciary duty to their clients to help out themselves or the other members of their firm. And that's a real tragedy. At St. Dennis and Davie, we're prepared to handle those circumstances and get justice for the client.